6. Today we talk more about prostitution, and we talk a little bit about police powers. So, to start off with the Bedford v. Canada case, this was a kind of a prologue to the reference on prostitution and the Fraser Committee. In 2010, Carrie Jean Bedford, who was a dominatrix and sex worker, and 2 other sex workers brought this case to trial. And the trial decision was to strike down the laws prohibiting bawdy houses living off the avails of prostitution and communicating for the purposes of prostitution as unconstitutional. And according to a survey, Angus Reid poll, it was supported by 49% of Canadians. On appeal, a year later, they restricted some of these decisions, I suppose, but they did change the status quo, and so they changed the restrictions regarding living off the avails of prostitution to just situations of exploitation. And they found that the law prohibiting bawdy houses should be stayed for 12 months to give Parliament time to change it so that it's not unconstitutional, it doesn't infringe on the Charter. And with regards to communicating for the purposes of prostitution, they found that it was reasonable under Section 1 of the Charter, though it does violate sex workers' Section 7 rights. So the Supreme Court of Canada has heard the arguments in June, and there should be a verdict very soon, hopefully. We also read a paper in her presentation by Maria Power, a former UNB student who did her master's thesis on prostitution. There's an interesting excerpt from her commentary regarding the impact of the PHS case on the Bedford Canada case. So, in the PHS case, which allowed the safe injection site to continue operating in Vancouver, the Supreme Court found that when it's empirically shown that the harms created by the law or are more severe than the harms prevented by it, then exceptions need to be made. So they found that the laws were both arbitrary and grossly disproportionate to the health and safety objectives of the Act and could not be upheld by the limitations in Section 1 of the Charter. So this is an interesting precedent because by the government's own research, street solicitation has not decreased since the laws prohibiting prostitution indirectly have been around. And they are increasing risks to street prostitutes. So while safe, orderly communities are a laudable goal, this order should not be achieved at the expense of the lives and well-being of sex workers. So kind of an interesting precedent in that case. So Maria Power came in to give a presentation on international models with regards to regulating prostitution. First, the Swedish one was started with the Violence Against Women Act in 1999, and it seems to follow certain logic anyway. It's aimed at criminalizing the Johns and not criminalizing the sex work. However, promotion of sex work remained prohibited. But selling sex was legal. So it was kind of an odd situation where you couldn't promote it, but you could actually be a prostitute or a sex worker. And I suppose it's similar to the situation we have in Canada, where communication is legal, but actually doing it is not. And the effects of the Swedish model were very similar to the Canadian model, where there's increased risk of violence. Prostitutes are doing it more covertly. There's decreased ability to negotiate safe sex, and anyway, just on and on, kind of limited access to health resources, hostile relationships with police. And she brought up one case of Jasmine, a sex worker who had children, and she would travel to Stockholm to work. It was about an hour away. And I think her sister-in-law, or her and her husband had split up, and her sister-in-law or someone found out that she was working as a sex worker and informed social services, and social services came and took the kids, and on the assumption that she was working out of her home and that it would be bad for her children, and gave them to her husband, who was abusive. Anyway, long story short, he ended up killing her, and she worked hard to get her kids back, and anyway, it was just sort of a terrible circumstance for this woman, whose, I guess, only crime was being a sex worker, but at the time I don't think it was criminal. Anyway, I guess it just kind of points out the stigma associated with it that remains. So in New Zealand, they took a different approach. Historically, they had the Massage Parlours Act, so this was not to legalize prostitution anyway. This was to license massage parlors and prohibited people who were convicted of using drugs or convicted of prostitution from working in massage parlors. And police would drop by unannounced and ask for sex and favors to see if they were following the rules. And the criminal law was a $200 fine, and you can no longer work in a massage parlor if you're found to be providing sexual acts. And during that time, they also used condoms as evidence. So if you had condoms on you, that was evidence that you were a sex worker. In 2003, they decriminalized it with the Prostitution Reform Act. And it allowed sex workers to operate on the street. It allowed them to form small enterprises with 4 or fewer prostitutes, where they would be licensed and subject to health and safety codes. Like according to the law, they must wear a condom. And since the new law has been in place, there's increased likelihood that prostitutes report incidences of violence, whereas before they wouldn't. Street sex workers are now more likely to work during daylight hours and in well-lit areas. And they noticed that the underage prostitution has not appeared to increase, which is kind of one of the main concerns of outlawing prostitution, is the impact that it might have on younger women who may consider that occupation. So the way it started was the New Zealand Prostitutes Collective, and this was similar to a labor movement. They band together to promote the rights of sex workers and also prevent HIV. The government wanted to prevent HIV as well, so they approached their collective and said, you've got an in with whatever community is spreading HIV, so here's some money for HIV prevention. And they said, take your money back unless you're willing to look at the criminal law, and so they did. The New Zealand Prostitutes Collective worked with the government to draft the Reform Act, and it was mostly based on HIV prevention. But the important thing to note here is that sex workers were at the table to help draft the legislation. And I guess one of the reasons it got through the political system was that because they have a mixed member proportional representation system leads to a diverse mix of people. This was a members' bill, so it wasn't sponsored by the government, which meant less political fallout. And members' bills just literally go into a biscuit tin, and when they get drawn out, they get voted on. And this one went in September 2000 and was drawn out a month later. So the purpose of the act was to decriminalize prostitution. It was to create safeguards for the human rights of sex workers, promote the occupational health and safety of sex workers, but it also prohibited sex work for people under the age of 18. So the impact was that they now had to use condoms, and basically just a much safer, healthier environment for sex workers. Reduced incidences of violence, more reporting, safer sex, less HIV, and the concern of the critics was that there would be prostitutes everywhere and everyone would get into prostitution was found to be unfounded, and that was not the case. So moving on to police powers and the kind of greater justice system. Here's a quote from class: "Crime is a socio-political artifact, not a natural phenomenon. We have as much or as little crime as we please, depending on what we choose to count as crime." And this is basically saying that crime is ever-changing and evolving, and it's kind of what we consider crime. With regards to the justice system and the process of trying criminals, there's a couple models put forward by Packers. The first is the conveyor belt and the next is the obstacle course. So the conveyor belt model is based on the fundamental constitutional idea of peace, order, and good government, and it's concerned with efficiency. It sees the justice system as a way to process potential criminals. And it's not about taking every case that comes across your desk and making constitutional challenges out of it, or charter challenges out of it. It's based on an expedient trial. That's about it. And there's also, I guess, some individual rights justification behind it, in that everyone has a right to expedient trial, and if everyone is trying to make a case out of everything, then it might clog up the justice system. The other model is the obstacle course model, and the ideas behind it are the charter rights of the individual, the rights to counsel, the right to full answer in defense, and in this case, the role of the defense attorney is to argue any possible issue. It doesn't matter whether it's efficient or not. So your client is the only person you care about, and your duty is to make sure that they get processed appropriately. The only issue here is that sometimes if you take this route, it could take 3 years to argue a case that the punishment for might be only 6 or 7 months. So there's kind of competing principles behind the two, and of course they're going to be balanced, and of course in some situations some are more important than others. So with regard specifically to police powers, pre-1982, the courts were less concerned with the rights of the individuals and more concerned with the process and the efficiency of the process. So here's one quote from class. So rigid formulas can be both meaningless to the weakling and absurd to the sophisticated or hardened criminal. Introduce a new right as an inflexible preliminary condition would serve no genuine interest of the accused, because sometimes the accused just want to get their story out, but add an unreal formalism to that vital branch of administration of justice. So here he's talking about police powers and things like your right to unreasonable search and seizure, the procedures that the police have to go through to make sure that they're not infringing on charter rights. And what he's saying is that we should trust the police professionals, trial judges, and evidence obtained in an unlawful way may serve the truth. But I guess more appropriately, some of these rules mean that we have less information from which to determine what the truth of the matter is. So the courts at the time, again, writs were easier to get, and they kind of deferred to the police. So there was more leeway for police to, I guess, infringe on people's rights than they would have just said to be police back then. And as I said before, the idea here is that if the police infringe on someone's charter rights, which the charter didn't exist at the time, in order to find the smoking gun, well, the smoking gun is important and it's found and it should be used in the trial. The other issue about police powers at the time was that the police misconduct discipline committee was questionable. So police powers now are limited by the charter, and the charter, with regards to legal rights, goes from section 7 to section 14. Section 7 is everyone has the right to life, liberty, security of the person, and the right not to be deprived thereof in accordance with the principles, except in accordance with the principles of fundamental justice. The right against unreasonable search and seizure, against arbitrary detention. If you are detained, you have the right to be informed promptly of the reason. You have a right to counsel and to be informed of that right. And you have the right to have the validity of your detention determined by way of habeas corpus, and to be released if the detention is unlawful. Section 11 outlines 8 features dealing mostly with the trial procedure. So not to be compelled to be a witness, not to be denied bail, to be informed without unreasonable delay of the specific offense. Your treatment and punishment cannot be cruel or unusual. And if you are a witness, you cannot incriminate yourself, and you have the right to an interpreter. So police have to respect these legal rights now, and if they don't, then the evidence is inadmissible, which is important because generally police go to an incredible amount of effort in order to gather the evidence to incriminate someone. And if they don't dot the T's and cross the I's, then the evidence can be used in court. That's Criminal Week 6.